20 after 4 p.m. I'm going to call the meeting to order of the Grant County Board of Adjustment. I will note that the staff from the 1st District will be participating in this meeting. They will offer our parliamentarian and board support for our reporting services. First thing is the items to be added to the agenda by any board members or staff. Are there any items? All right. Then we have an invitation for citizens to schedule time on the Board of Agenda, or the Board of Adjustment agenda for any item that is not listed. If we're discussing that item and you want to speak, your time will come up. But if there's any item that is not listed, we can put you in the end of the meeting. Christy has indicated. And your topic? I'm sorry, and your topic, Christy?
My email this morning to the county.
Concerning an email. Anyone else? All right, we have approval of the agenda. I will take a motion to approve the agenda.
So moved. Second.
I have a motion and a second. Any other discussion? All in favor signify by saying aye.
Aye.
Opposed, nay. Motion carries. Agenda approved. All right, we have the approval of the minutes from the November meeting. And I would entertain a motion to approve.
I make a motion to approve. Second.
I have a motion to approve and a second. Any other discussion? All in favor signify by saying aye.
Aye.
Opposed, nay. Minutes approved. All right, at this time we have to ask if any board members have any conflicts or ex parte communications that would make them unable to participate in the hearing or give the applicant a fair hearing.
Madam Chair, I have a conflict on the Dakota Ranch 3. Due to, I have a family member with property in the west boundaries.
Okay? So you would like yourself recused from the
Recused,
hearing?
yeah.
When we get to the hearing, of course.
All right.
Just on the hearing portion.
I just want to disclose, I have
You and Richard are in the schools as well.
yeah, I have a property easement with Dakota Range 1 myself. As to this project, I do not have any financial or personal gain from it, but I want them to have a fair hearing. I don't feel it's going to affect my vote. Is anyone in dispute of that, or?
And you and Richard need to talk about item 3 on the agenda. Motion to reconsider,
Yeah, see, we can't hear back here.
motion to reconsider, you'll have to step down from that as well.
Oh, yes, I understand. Richard and I will, if the motion to reconsider the prior hearing, we will be recused. Okay. Any other conflicts of interest that need to be noted? No, I just wanted to disclose that I was a part of the original Dakota Range. I do not have any interest in this particular project at this time, so. Okay?
Yep.
All right, we have a address from the state's attorney. He would like to speak to us for a few minutes.
Thank you, Chairman. I don't know that I can get this done in just a few minutes, Nancy.
No, that's
so
fine.
I hope
I'll
that,
give you all the time you want.
I hope you'll bear with me on this. First of all, good afternoon, gentlemen.
You're back here.
Fans are really loud.
Is there something that can be done to improve the acoustics here?
Please turn off those dehumidifiers if you can find the switches, please. Unplug them.
What are the fans or above?
No,
That's
they're
what's-
them. think it's a
The dehumidifier.
I think it's the dehumidifiers running back there.
Reach behind you and turn down the thermostat so the fan stop. Down. There you go.
Try it.
There should be, yep, there.
Can you hear me fine? I'll try to use my dad voice here, but maybe the microphone will help or won't, I don't know. Just for everybody's information, I was invited to come before the Planning and Zoning Board by Mr. Kays, and also presumably the board, to discuss certain issues and legal matters pertaining to your duties and responsibilities as board members of the Board of Adjustment, and also in your capacity as members of the Planning Commission. First of all, before I get going, I just want to take a moment to thank you. Thank each of you for the service that you give to Grant County, and also to the citizens of Grant County. I think there are a few people that really know and understand how hard you work and how diligent you are in trying to do things the right way. And I hope I can help in that regard. I know that your duties are difficult. You have to bear in mind that landowners have protected rights to their property, and on the other hand, government has a responsibility to promote the public health, safety, and welfare of its citizens. And balancing those, I think, highly complex issues is not only very challenging, but I also applaud you for the effort and intellect and the talent that you bring to these type of matters. Again, your job is not easy. In the words of one of my old law professors, John Davison, he said, "Bold and innocent is the commission which accepts such a charge." And again, I want to commend you for all that you do and express some gratitude. I hope everybody here feels similarly and gives you the respect and courtesy that you deserve, I think, as a matter of course. In preparing for this, I've made some, prepared remarks that I'd like to go through with you and discuss your roles and responsibilities as board members and generally about your powers and responsibilities. I also think it's important to know where those powers come from, how they're derived, and I want to discuss some guiding constitutional principles with you, and basically how the Constitution and the courts have settled on the relationship between property rights and the government's interest in promoting land use management. Some other topics that I'm going to discuss with you in more detail are some of your quasi-judicial responsibilities when you're acting as a Board of Adjustment, because when you're acting in that capacity, there's a substantial amount of due process that applies. I want to discuss some other topics such as conflict of interest and ex parte communications, both as they relate to quasi-judicial proceedings. So I guess with that being said, I want to discuss what our federal and state constitution tells us about our basic right to own property and how that relates to the government's power to affect land use through zoning regulation. The important place to start with that is the Constitution. The founders of our government were concerned with a wide range of human rights. Property rights were very high on their list. You know, history tells us that at the time this country was founded, citizens were tired of the British government, and they wanted to be a free and independent nation. They created the Constitution. The founders of the Constitution considered ownership of property was a cornerstone of liberty, the protected liberty interest that we have in the United States as United States citizens. John Adams said that property must be secured or liberty cannot exist. James Madison, the principal author of the Constitution, said that government is instituted to protect property of every sort, and that is not a just government, nor is property secured under it, where property which a man has is violated by arbitrary seizures of one class of citizens for the service of the rest. Since property rights were a fundamental and basic principle that the framers of our Constitution embraced, the government's power to regulate land use is limited. South Dakota's basically the 5th and 14th Amendments of both federal and state constitution contain a due process clause which prohibits the government from depriving a person of life, liberty, or property without due process. The 5th Amendment also contains a taking clause which prohibits the taking of private property for public use without just compensation. The other power, those type of actions generally involve actions called condemnation. But the other power that governments have to affect private property rights are zoning. And the government's power to affect people's rights through zoning legislation derives from the general policing powers conferred upon the federal government to the states by the 14th Amendment. Police powers are generally defined as the authority of the government to regulate the general health, safety, and welfare of its citizens. In constitutional terms, police power is the power the government has relating to matters affecting citizens so long that they're not barred by the Constitution. So the police powers are the basis for land use planning in the United States. That authority has been delegated to local government, generally county government. The constitutionality of zoning was first addressed in a U.S. Supreme Court decision in 1926 called Village of Euclid versus Amber Realty Company. That case dealt with height restrictions imposed in the city of New York. What's important about the Euclid case is that the court found that such restrictions were constitutionally permissible under the state's policing powers. The court cautioned, however, that these powers must be applied equally in all circumstances, and that the government's interference with an individual's right must be reasonable and have a clear relationship with some legitimate legislative purpose in promoting the health, safety, and welfare of its people. Ever since Euclid, all cases, state and federal, have followed that basic premise that zoning regulations not only have to be reasonable, but they cannot be arbitrary, and they must bear a reasonable and substantial relationship to the health, safety, comfort, morals, and general welfare of its citizens. That's where the Constitution and the courts have settled on the relationship between constitutionally protected rights to property and the government's interest in promoting wise land use management. With those principles in mind, in the early 1970s, Grant County, through its newly formed Planning Commission, promulgated a comprehensive zoning plan and a zoning ordinance. The purpose and function of that plan and its ordinance was to divide the county into various districts or zones and defined what the preferred use was of that property, and also other conditional uses that were permitted but subject to regulations or conditions. This was done to separate and provide buffers between land uses that were deemed to be incompatible or antagonistic. Usually comprehensive plans classify areas of the county into districts or zones such as residential, industrial, agricultural. The idea was to create more harmonious land use within the county and to protect the social, economic, and environment and development of the county. In 2004, our zoning ordinance was amended, and a wind energy system wind energy systems were added to the list of conditional uses in the subdivision A agricultural district. Through the regulatory authority of our comprehensive zoning plan, this meant that land use was confined to that area of the county because that land use was inherently undesired or had inherent undesirable consequences. The zoning regulations that were adopted by the county commissioners, were meant to minimize but not eliminate those undesirable consequences by locating them in a zone that was considered more preferable and by regulating them through specific conditions that are outlined in section 1211 of the ordinance, such as setbacks, height restrictions, spacing requirements, and etc. It's important to recognize here that wind energy systems are a permissible land use in Grant County. Our ordinance permits this if the applicant meets the requirements of the ordinance. This is where the Board of Adjustment's responsibilities apply. Your purpose and function as a Board of Adjustment is to fairly and impartially review applications at a fair and impartial hearing, and to determine whether applicants have or have not met the requirements of our ordinance. The ordinance is the law that must be applied. The rules and regulations that apply to wind energy systems are not up to you to decide or debate or pass judgment on. Those are legislative matters. Your responsibility and your sole and exclusive responsibility is to apply those regulations. When you do so, you act in a quasi-judicial function. A quasi-judicial proceeding is a hearing that requires, or is a proceeding that requires a hearing, generally on variances or conditional use permits. Legislative or rulemaking proceedings are not quasi-judicial. Those type of proceedings create rules and regulations on policy matters where the effect will be in the future, ongoing. When acting as a planning commission, you are quasi-legislative in that you do have an influence over rulemaking policy and ordinances. You review the ordinance and make recommendations to the county commission concerning any amendments or changes that you deem appropriate. That function is quasi-legislative. You do not have the actual rulemaking authority. You are limited to making recommendations only, which can be accepted or rejected by the county commission. These distinctions are important to understand because different standards of due process apply to each type of proceeding. For example, a party who believes that they are aggrieved by a decision made by a Board of Adjustment has a mechanism of appeal. They can appeal from that decision based on what's called a writ of certiorari. There's no such appeal from a recommendation of a planning commission, and there's no such appeal following the adoption of a legislative decision. There is a remedy, and that remedy from a legislative decision, such as the county commissioners would make, is called a referendum. And as I've indicated, when the original zoning ordinance was adopted in the early 70s and been amended or modified many times over the succeeding years, that remedy of referendum has always been available, and once the time period is passed on those ordinances were made law. Now, getting back to your quasi-judicial function as a Board of Adjustment, it's my understanding that relative to an application made by, I think it's Crown Ridge, there was a motion made but tabled to increase the setback for that application to 3/4 of a mile. Am I correct in that?
Yes.
I don't know the reasoning behind that condition, but it strikes me as being legislative in nature. It strikes me as being it strikes me as changing the rules in the middle of the game. This application was made and submitted for your consideration under the existing rules as they existed at the time the application was filed and as they exist through all phases of this proceeding. My point being, you can't change the rules in the middle of the game by imposing a condition on an applicant that they perhaps could never meet. That would be a classic example of an ex post facto law. So my point being is that the rules and regulations that were in place at the time that application was made apply during all phases of the quasi-judicial proceeding. Grant County, by its ordinance, establishes a setback distance of at least 1,000 feet. Grant County, the commission, drafted and implemented that ordinance. And in doing so, they did so to promote the health, safety, and general welfare of its citizens. That's their responsibility, to determine and to adopt ordinances that ostensibly provide for the health, safety, and well-being of the citizens of Grant County. Those are the rules and regulations. They were not challenged by referendum. They became law. Any changes that the Planning Commission may present to the County Commission are prospective in nature, forward going, and would only apply to future applications. Now, this is where it gets a little bit different. Can the Board of Adjustment never increase a setback? I'm not saying that. There are words in the ordinance that say at least 1,000 feet. But if you increase that distance, it would have to be based on and require a finding of some very exceptional circumstance. There would have to be a very circumstantial, fact-based nexus between that increase in distance that would justify a departure from what Grant County considered to be an acceptable setback. For example, if the proposal was to site this wind farm right pertinent to an airport, for example, obviously there would be a definite and necessary need that a setback in that particular location would be appropriate. To do it for some other reason, or for a reason that would be because you as a Board of Adjustment just disagreed with what the ordinance requires, or think that it should be different, that would be improper. That would be legislative in nature. The Supreme Court has been highly critical to a particular Board of Adjustment in the case of Hines versus Board of Adjustment of the City of Miller. In that case, which concerned a variance request, the court determined that the board's denial of that variance was solely based on a list of concerns presented by a group of neighbors. Primarily, they just didn't want a mobile home in their area. The court, and I'm quoting the court's language here, we have condemned this type of arbitrary decision-making in the past. In Cary versus City of Rapid City, we struck down a statute that rested, quote, the ultimate determination of the public interest with a group of neighbors. There we reasoned the ultimate determination of the public's interest is for the legislative body, not a minority of neighbors or property owners. Because the Constitution protects a landowner's right to use land for any legitimate purpose, we are wary of decisions that are based on the whims of neighboring landowners. This is so because their decisions may be lacking any standards or guidelines, leading to decisions that may be arbitrary or capricious. Worse, their opinions may be wholly self-serving. The court in Hines ruled that the Board of Adjustment did not feel its duty to follow the guidelines of the city ordinance. And by not doing so, its decision was deemed to be arbitrary and